Sir has practicing last 1994. The area of specialization is criminal law, domestic violence, Negotiable Instrument Act, revenue matters, and others. From last 18 years, sir has good experience about bail matters, session trial court, appellate work, free legal ad schemes, mediator, and empaneled counsel on the two national and other cooperative banks also. So dear students, without waste of your time, I just request to our honorable guest, Advocate Avtar Saji, to take the charge of the session. Sir, over to you.
Good morning to all students, and especially for Harshali.
Good morning.
This opportunity has been given. I am very grateful to her, and I feel honored to focus on Negotiable Instrument Act to my colleagues, my dear students. Negotiable Instrument Act is enacted in 1881. You may think that this is the old act and now the situation is changed, but how this act will be effected? So with this doubt, I want to hello.
Yes, sir, you are audible.
हाँ ऑडियो हाँ. तो आप सोच रहे होंगे कि एक 1881 में बना हुआ है और आज की पोजीशन में ये कैसे अप्लीकेबल हो सकता है. तो उस बारे में मेरा कहना ऐसा है कि टाइम टू टाइम उस एक्ट में अमेंडमेंट हुआ है, और जैसी जैसी परिस्थिति बदली. आ रही आवाज मेरी? हेलो.
Yes, sir. Students, are you audible?
Yes.
हाँ. तो समय के हिसाब से उस एक्ट में अमेंडमेंट होता है, पार्लियामेंट उसको अमेंडमेंट करता है, सिचुएशन जो क्रिएट होती है उसको सॉल्यूशन करते हैं, सॉल्यूशन करके उसको एक्ट में अमेंडमेंट करते हैं. आ रही ना आवाज मेरी?
Yes, sir, you are audible.
Yes, sir.
हेलो, आ रही आवाज?
Yes, sir. Now you're audible.
हाँ, अच्छा. Most of the negotiable instrument transaction can be categorized into three parts. However, there are no explicit statement that it is a limited or it must be specified into only three parts. The negotiable instruments are categorized in three parts: promissory notes, bill of exchange, check. Promissory notes is defined in section 4, bill of exchange is defined in 5, and section 6 define the check. Now we will see the what is promissory notes. आप सुन रहे सभी मुझे? हेलो?
Yes, sir.
हाँ. Promissory notes, what is meant by promissory notes? This transaction generally takes place between the debtor and the creditor. The debtor creates the instrument promising the amount of money on a specified date. And with respect to bill of exchange, this is just opposite to the promissory notes, as this is an order from the creditor to the debtor. Here the creditor makes the instrument that instruct the debtor to pay a payee a certain amount of money. This bill is called by the creditor, created by the creditor. Check. What is meant by check? This is just one of the forms of bill of exchange. In this case, the drawee is a bank, and such checks are payable on demand. The bank is instructed by the debtor to pay a certain amount of money to the assignee payee. Let us we have looked at the purpose of Negotiable Instrument Act. The Act aims to create the legal provision for the negotiable instrument system that is currently in operation throughout the country. The regulatory laws would systematically organize the systems, and Act would define a disputes authority to decide any issue relating to the negotiable instrument. Now, who is the drawer, drawee, and acceptor? The drawer, the parties to the bill of exchange. The drawer, who is the drawer? The person who gives the order to pay or who makes the bill is called the drawer. In this case, drawer issue the direction, issue a direction to pay, or who makes the bill is called the drawer. The drawee means the bank, or the party, the person who is directed to pay is called the drawee. The drawee may be bank or any persons. When the drawee accepts the bill, he is called the acceptor. The payee, the person to whom the payment is to be made is called the payee. This is the definition of the drawer. Definition of the expression the drawer, the drawee, and the payee. So if any doubt, I can repeat it. Who is the drawer? Hello student, can I repeat it? हेलो, आप सुन रहे मुझे सभी? हेलो?
Yes, sir, you are
Hello?
audible.
हाँ, audible. And okay. Just 1 minute. Now, who is the holder and who is the payee? The payee is the person named in the instrument to whom or to whose order the money is by the instrument directed to be paid is called the payee. Now, who is the holder? The holder of promissory note, bill of exchange, or checks means any person entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. Now, a negotiable instrument means a promissory notes, bill of exchange, or check payable either or to order to bearer. In this case, there may be endorsement. That endorsement is defined in section 15 when the maker or holder of negotiable instrument sign the same, otherwise than as such a maker for the purpose of negotiations on the back or face thereof or on a slip of paper annexed thereto, or so signed for the same purpose, a stamp paper intended to be completed as a negotiable instrument. He is called said to endorse the same and is called the endorser. Now, endorsement may be in blank or in full. If the endorsee sign his name only, the endorsement is said to be in blank. And if he adds direction to pay the amount mentioned in the instrument to or to the order of or specified person, the endorsement is said to be in full. So endorsement, there may be endorsement in blank or in full. Sometimes it occurs that when amount is stated differently in figure and words, if we see the check, on check, their amount is differ from the words. In that position, there is a provision in Negotiable Instrument Act, Section 18, where amount is stated differently in figures and words. So, what amount will be directed to pay? This may question arise. In that situation, if the amount undertaken or ordered to be paid is stated differently in figures and in words, the amount stated in words shall be the amount undertaken or ordered to be paid. This question, now I have a lot of years of practice, but this provision is came to my knowledge when I was preparing this session. I'm thankful to the sessions that I got one knowledge that when there is a difference in figure and words, when in respect of maturity, there is a provision of section 22, maturity. The maturity of promissory note or bill of exchange is the date at which it falls. Now, when the day on which the promissory note or bill of exchange its maturity is a public holiday, when date is fixed on a day which is public holiday, the instrument shall be deemed to be due on the next preceding business. This is the doubt is also clear by the act. Now, in which manner the discharge from the liability on notes, bills, and checks? There is a provision of section 82, discharge from liability, the maker, acceptor, or endorser, respectively, of a negotiable instrument is discharged from the liability thereon by cancellation, by release, by payment. Thereby, he can discharge his liability on which occur on the bills and checks. Now, if there is a alteration, sometimes after issuing or before issuing, if there is alteration, there is a provision with respect to the material alteration. Respect, there is a provision of section 87, effect of material alteration. Any material alteration, Negotiable Instrument Act renders the same void as against anyone who is a party thereto at the time of making such alteration and does not consent thereto unless it was made in order to carry out of the original parties. If there is any alteration which is without the consent of the maker, the negotiable instrument is void. And if alteration is made by the endorsee, alteration by endorsee, and such alteration, if made by an endorsee, discharges his endorser from all liability to him in respect of the consideration thereof. So there should not be alteration by endorsee. And some cases, payment of instrument on which alteration is not apparent. If there is no alteration is prima facie visible from the negotiable instrument, payment is to be paid. Now, in negotiable instrument, there is a presumption. This is the special act, and it is a settled principle of law that when there is a special act, which prevails over the General Act. In this case, in this act, there is a presumption as to negotiable instrument until the contrary is true. The following presumptions shall be made. In there is a section 118. What is the presumption? Presumption regarding the consideration. Presumption regarding the date, as to the time of acceptance, as to time of transfer, as to time of endorsement, as to stamp that holder is due in course. This is the presumption. Thereby, act has a presumptive value. Now, regarding the presumption, in this case, there is a presumption of consideration and so on, etc. That presumption is a rebuttable presumption. And if any contrary view has been proved by the in defense, that presumption goes. Now, with respect to defense, this act is provided a estoppel against denying capacity of pay to introsy, no maker of promissory note, no acceptor of bill of exchange shall ensue thereby a holder in due course be permitted to deny the pay's capacity at the time of note or bill or to engross the same. In this case, there is a provision of section 138. In 138, we see that it is a provision regarding the dishonor of check. In this case, if check is dishonor, at the time of dishonor, what is the precaution is to be taken for filing the complaints? Now we will see the how dishonor of check provision is there, where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part, check can be issued for the liability of a part and whole and other liability is returned by the bank unpaid, either because of the amount of money standing on the credit of that amount is insufficient to honor the check, or it exceed the amount arranged to be paid from that account by an agreement made by the bank, such person shall be deemed to have committed an offense without prejudice to any provision of this act, be punished with the imprisonment for a term which may extend to 2 years of, or with fine which may extend to twice of the amount, or with both. In respect of dishonor of check, there is a punishment provided for 2 years or with fine which may extend to twice the amount of the check, or with the both. But for dishonor check cases, there should be a condition which are essential. The check has been presented to the bank within a period of 6 months. This 6 months has been removed by the notification of the Reserve Bank of India. That 6 months is removed by substituted by 3 months. So check should be presented for encashment for in a validated period. On a dishonor of the check, then intimation is to be intimation is given to the person regarding the dishonor of check. He must be issue. He should issue the notice by making a demand of check within a 15 days. If 15 days has been elapsed, then cause of action is started. So, student, cause of action is notice is to be issued for 50 days after getting an intimation of dishonor, and there should be opportunity should be given to the drawer to make a payment of the check within 15 days. If 15 days has been elapsed, then cause of action will be started, and that when the cause of action is started, it should be within 1 month. It should be within 1 month. Complaint is to be filed before the court. In this case, police authority has no authority to investigate the matter. So, considering this aspect, there must be procedure should be adopted to file a complaint. In this case, the purpose of this section, debt or other liability, means legal enforceable debt. If check is not issued for legal liability, the complaint will be dismissed. Regarding the presumption, there is another section, section 139, presumption in favor of the holder. It shall be presumed unless the contrary is proved that holder of a check receives a check of the nature referred to in section 138 for the discharge in whole or in part. So these are the provision regarding the presumption of the check. Now, in this act, there is a provision of section 140, defense which may not be allowed in any prosecution under section 138. It shall not be a defense in a prosecution for an offense under section 138 that the drawer had no reason to believe when he issued the check that check may be dishonored on presentment for the reason stated in that section. This cannot be a defense for the accused or the drawer who issued the check. Now, if the offense is committed by the company, then there is a provision of section 141. Who is the responsible for commission of the offense? There is a special provision regarding the offenses by the companies. Now, if the person committing an offense under section 138 is a company, every person who at the time of the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense. Now, company means, what is meant by company? Company means any body, corporate, and includes a firm or other association of individuals. Director means in a relation to a firm, means partner in the firm. Now, regarding the cognizance of offense, there is a special provision regarding the cognizance of offense. In this case, court is empowered to take the cognizance. And regarding the cognizance offense, there is a provision in section 142 of Negotiable Instrument Act. In this case, if anybody wants to file a complaint, so it should be in a proper way there, and because court is barred, so 152 cognizance, no court take cognizance of an offense punishable under these sections upon a complaint in writing made by the payee or as may be the holder in due course. So first condition of this regarding the cognizance of this offense is that court will take a cognizance of an offense punishable under section 138 upon a complaint only. That should be in a writing made by the payee, or the case may be the holder in due course. Such complaint must be within 1 month of the date on which the cause of action arises, according to section 138C. What is the cause of action? When the check is dishonored, when intimation regarding the dishonor is given to the payee, and he issued the notice to the drawer to make a 15 days time, and if 15 days has been elapsed, that will create a cause of action to file a complaint. In this case, if complainant has failed to file a complaint within 1 month, there is a provision in Act that if a sufficient cause has been given and complainant failed to file a complaint in a prescribed rate, if the complainant shows the satisfy the court that he has a sufficient cause for not making complaint with such period, on this ground, if a court convince the grounds and condone the delay, court is competent to take the cognizance of the offense. In this case, who is empowered to take the cognizance of offense? In this case, no court inferior to that of metropolitan magistrate or a judicial magistrate of the first class shall try an offense punishable under section 138. Now, in whose court the complaint is to be filed? The offense under section shall be inquired and tried only by court within whose jurisdiction, if the check is delivered for collection through an account, the branch of bank where the payee or holder in due course, the case may be, maintains the account institution, or if the check is presented for payment by the payee or holder in due course, otherwise through an account, the branch of the drawing bank where the drawer maintains the account is situated. In this case, the jurisdiction of the court is defined in section 142(4). If the check is presented for payment by the payee or holder in due course, otherwise through an account, the branch of the drawing bank where the drawer maintains the account is situated. Now, what is the power of court? How the case be conducted? So, regarding the trial of the court, there is a provision of 143 that is amended. In this case, the trial be conducted by the judicial magistrate of the first class or by metropolitan magistrate. In this case, there is a provision of trial which is prescribed in a criminal procedure code of law and provision of section 262 to 265. This is the provision of the CRPC which is applicable to the power of court to try the case summarily. In this case, in a summary cases, imprisonment for term not exceeding 1 year. If according to this provision, if the court feels that the punishment be given to more than 1 year, the magistrate shall, after hearing the parties, record an order to that effect and thereafter recall any witness who may have been examined and proceed to hear or rehear the case in the manner provided by the said court. So there is a provision regarding the enhancement of the punishment, how the procedure be applied by the judge, by the metropolitan magistrate or judicial magistrate. how to enhance the punishment. Now there is a now in 138 cases, pending cases, there are too much delay practice is applied by the accused persons. So regarding this provision, regarding the delay practice adopted by the accused, the act, negotiable act, is amended by section 143A, power to direct interim compensation. The court trying an offense under this section may order the drawer of the check to pay an interim compensation to the complainant. In a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint, and in any other cases, order if the charge is framed, this provision is applicable. So there is a power to direct interim compensation. Regarding the benefit for the complainant, as delayed tactics is applied by the accused, so to avoid the harassment to the complainant, the provision of interim compensation is amended, added in this case. So in this case, for interim compensation, there is a limit. Court can empower to grant an interim compensation to the complainant up to the 20% of the amount of the check. There is a provision for period in which the interim compensation is to be paid to the complainant. It shall be paid within 60 days from the date of the order under subsection, within such further period not exceeding 30 days. So there is a provision of 20% is to be paid by the drawer to the complainant within 60 days, and that 60 days can be extended only by 30 days if sufficient reason has been shown by the accused. And in a situation, if in a complaint case, are you hearing now? Hello?
Yes.
Hello?
Sir.
Ha. If in a situation, complaint case judgment is in favor of the accused person, and already the interim compensation has been ordered, and that is paid by the accused to the complainant, that can be recovered on the pronouncement of the after acquittal order. This is the provision. And regarding the period, that is same 60 days, and that period is extended for 30 days. Now, regarding the mode of service of summons in a complaint case, which mode of service of summons is to be adopted? There is a provision of section 144. Summons to an accused or a witness may direct a copy of summons to be served at the place where such accused witness ordinarily resides or carries on business or personally works for gain by speed post or by such a courier service. Now, what is the provision of evidence? In this case, there is a section 145, evidence on affidavit. Complainant is entitled to file an affidavit in the form of his evidence. Regarding the documents of transaction, presentation of slip, dishonor of check, notice of intimation, memo of intimations, there may be reasons why the check is dishonor. These falls under section 146, bank slip. Prima facie evidence of certain facts, the court shall, in respect of every proceeding under this chapter, on a production of bank slip or memo having thereon the official denoting that the checks had been dishonored, presume the fact of dishonor of the check unless and until such fact is disproved. During trial, these documents is most essential to show the ingredients of the dishonor of the check. Regarding this document, there is no need to examine the bank officer. If the documents are according to the procedure, it is properly signed, properly sealed, so no need to examine other witnesses of the banks if the documents is proper form. Now, regarding the compoundable, the offenses under section 138 of negotiable instrument is a compoundable, and they in a provision of 147 there is a provision to compound the offense. If the offense is compounded, it will give the effect of acquittal under section 320 of 328 of CRPC. So if the offense is compounded, it amounts to acquittal. Now, there is another amendment, section 148, power of appellate court to grant a payment pending appeal against conviction. In this case, interim, it is an additional amount with respect to interim compensation awarded in view of 143. Extra order to payment can be made by the appellate court. There is a provision of section 148, power of appellate court to order payment pending appeal against conviction. In this case, in an appeal by the drawer against the conviction under section 138, the appellate court may order the appellant to deposit such sum which shall be minimum of 20% of the fine or compensation awarded by the trial court, provided that the amount payable under this subsection shall be in addition to an interim compensation paid by the appellant under section 143A. I have already submitted. This is the additional order of payment to the complainant. And regarding this provision, same period has been given as section 143, 60 days from the date of order, or with such further period not exceeding 30 days as may be directed by the court on sufficient cause the being shown by the appellant. And if the appeal is allowed, the drawer succeeded in appeal filed against the conviction order. In that situation, appellate court can direct to the complainant to pay the amount of compensation that which is received by the complainant within a period of 16 days, and as if sufficient cause, 30-day may again can be granted. So these are the provisions. In short, I tried to focus in a very short time. There may be some sections which I cannot tell about that. So if any person, if any student has any doubt, I am ready to try to convince to provide a answer to the queries. Hello.
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 Hello. Sir, what are
madam.
the reasons for dishonor of check? Can you just list down that?
What are the if
Reasons
the
for
check
dishonor of a check.
dishonor of the check, there may be insufficient amount, there may be a variation in signature, incomplete check, it is not properly written, no name of the pay is written, no date is mentioned. These are the grounds.
Okay, sir. Thank you.
Huh. Huh. Any more question?
No, sir, please
And
continue.
if the check is, if check is not presented in a valid time, that can be one of the ground. Now, in prosecution of the 138, issuance of notice is essential. Without issuing the notice of dishonor, no complaint can be filed, no cause of action can be arise. So precaution should be taken to issue a proper notice. There is a no format or prescribed format. Only in notice we have to submit the transaction relation, how the check is given, whether the check is for discharging part of the liability or full satisfaction of the liability. The liability should be a legal liability, and there must be an opportunity to the drawer of 15 days, which is mandatory. So when we issue the notice, there must be a demand of amount of check within 15 days from the date of notice, from the receiving the notice of demand. And if a 15 days has been elapsed, then cause of action is will be arise, and for that cause of action there is a prescribed rate of 1 month. Within 1 month, when 15 days has been expired, and within 1 month, complaint should be filed in written to the court having jurisdiction. And if in a prescribed period of 1 month, if no there is a ground, there is a reason for not filing the complaint within prescribed period, so complainant must establish the facts that due to some bona fide reason and satisfactory reason that he could not file a complaint before the court by these grounds, and on satisfaction of these grounds, court can take a cognizance of the complaint after completion of the 1 month. And if we issue the notice, some tactics has been applied by the drawer that they avoid to receive the notice as a mode. They use house is locked and not residing, or intimated but he not received the notice. So no need to frighten. According to 138, according to the procedure of Negotiable Instrument Act, only issuance of the notice is mandatory. There is no provision that it should be received by the drawee. So there is no need uh, to take a worry on this ground. There are a lot of judgments of apex court in which tactics of not receiving by the notice is established. So we can file the complaint by showing that check notice has been issued for demand of the amount. So I want to sum up my sessions. If any more query, I am ready to answer it. Hello.
Yes, sir, you're audible.
हाँ हाँ, और कुछ रहा क्या मैडम? अब ये दो प्रकार के now instruments are two types. एक minute, just wait. When the check is issued in India, it, when promissory note, bill of exchange, or check drawn or made in India and made payable in or drawn upon any persons resident in India shall be deemed to be in inland instrument. Now, opposite to this definition, foreign instrument, any instrument which is not so drawn as an inland instrument in India are the foreign instrument. Now, why this act is enacted? To regularize the transaction in a smooth manner and proper as per the procedure to fix the liability, this act is enacted. Now, uh, from time to time, there are amendments regarding the difficulties arise in during trial or application of this act. Time to time, this act is amended. There is a provision of the interim compensations during the proceeding of the pendency of the trial. Trial mode is also explained. That is some summary trial, and in appellate court there is also provision of the compensations to be paid by the drawer to the complainant. In a short time, I tried to convince the act. That is not possible, but I tried to sum up my uh, uh, sessions on this act. I thank to Dr. Harshali. Hello, any more question? Hello, I'm
Yes,
ready
sir.
to answer. I'm ready to answer any question of the student, and
Yes, student, would you like to ask any question?
I am also ready to repeat if any doubt or regarding any provision.
Sir, some kind of cases, if you discuss with them, any cases regarding that Negotiable Instrument Act.
Huh. Just 1 minute.
Current, yes, sir.
Uh, One recent judgment regarding if the check is issued for 1 lakh and question may arise if drawer has paid 20,000 to the holder, then there is a liability of 80,000 to be remain. In that situation, it is the duty of the payee to may endorse on the check that he has received the 20,000 rupees. Now he has to recover 80,000. If that is not mentioned, there may be chances of acquittal. Because there is no liability of 1 lakh, he has already received the 20,000. So in that situation, he should endorse on the check that 20,000 has been received. This is check, though it may be a 1 lakh, so he has to receive only 80,000. Now, one principal guidelines has been given in Basalinga. I will focus on some guidelines in the judgment delivered by the Honorable Supreme Court. In Czech, there is a two main sections. Section 118, presumption as to negotiable instruments. Until the contrary is proved, the following presumptions shall made regarding consideration, date, and in respect of section 139, there is a presumption in favor of the holder. In Balasinga judgment, Honorable Supreme Court have summarized the principle enumerated by the apex court in the following manner. Now I will call your kind attention regarding the principles. Once the execution of check is admitted, Section 139 of the Act mandates a presumption that the check was for the discharge of any debt or other liability. The presumption under Section 139 is rebuttal presumption, and onus on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that preponderance of the probability. In view of this principle, accused has to raise the probable defense. So burden upon the accused is not so high as the prosecution. To rebut the presumption, it is open for the accused to rely on the evidence led by him, or accused can also rely on the materials submitted by the complainant in order to raise a probable defense. Inference of preponderance of probabilities can be drawn not only from the materials brought on record by the parties, but also by the reference to the circumstances upon which they rely. That it is not necessary for the accused to come in the witness box. It is a settled principle of law. No need to prove his case by entering in witness box. In support of his defense, Section 139 impose an evidentiary value and not a pursue burden. It is not necessary for the accused to come in the witness box to support the defense. These are the principles summarized by the Supreme Court in Basalinga versus Mudiba Sapa. Supreme Court डिवीजन बेंच का जजमेंट है. If any complaint is filed and accused is residing in another jurisdiction, so question may arise whether court can issue a process to the accused to appear in the case. So for that respect, there is a provision adopted by the court to make an inquiry, and after satisfaction of that, the court can issue a process who is not residing within his jurisdiction. Hello guys, any more question? Hello,
Yes, sir.
hello. Any more
Students, would you
question?
like to ask any question regarding that? No question, students?
No.
I can repeat another, any provision if any doubt in any provision which I have already explained.
Any question comes in your mind? No question? Yes, sir, I just want to ask one question. Ki nowadays means from last 20 to till date 23, it's all our digitization. So all
Yes.
industry or every corporates use the what
Ji-
phone pay and NEFT and all. So check is very less used, right? So
ji,
same
ji.
provisions is applicable if some kind of fraud happen in companies and other industries.
No, electronic check is permissible.
Okay, electronic check is permissible. Yes, yes. Thank you
Permissible.
so much.
Ha.
Yes, means
Ha.
whatever the transactions you
And in
require
respect
to
of
buy any kind of loan.
in respect of NFT,
Mhm.
they have to pay first. So already payment has been recovered. So no
Yes,
need of
but sometimes
additional.
sometimes what happens, sir, they have just show the transaction, but sometimes what the network issue or technology issue now that it has been show ki yes payment has been done, but the next party it will
No,
not receive.
so it should be confirmed from the bank whether the amount has
Okay.
been deposited or not. And a
Yes.
precaution should be taken.
Yes, they have a transparency of that transactions,
Ha,
right? Bank and
ji,
other party, right?
ji.
Yes. Right, sir. Yes. Yes, students, would you like to ask any questions regarding that? Okay, no more question. Okay. So, thank you so much, sir,
Thank you.
for the
Welcome.
session. Yes, and you are give us your precious times for us, and it's really wonderful session. You just clear the some kind of issues regarding section 138 and 139, how it is applicable for that particular Negotiable Instrument Act. I hope all students understand, and I request to all students, if you want to ask any questions, please may ask. Okay, so I request to all students, please fill the feedback form. I'll share it your chat box. Okay, and sir,
Ji.
yes, thank you so much. Thanks a lot for that session, sir.
Welcome.
Yes, thank you, sir. Okay, sir. Bye bye. Take care. Good day,
I'm
sir.
grateful to you all that you have given opportunity to me to carry out the sessions.
Thank you, sir.
Thank you.
I'm also thankful to you to take the session, sir.
Thank you, sir.
Next time,
Thank you, ma'am.
हाँ, okay.
Yes, sir. You may leave now.
Okay. Thank you.